A unanimous Supreme Court decision came down that has fundamentally and permanently rewritten gun law in every single corner of America. And here is what makes this truly historic. All 9 justices agreed. Not 5, not 6, not 7 or 8. All 9, including the 3 liberal justices who have spent their entire careers on that bench, voting to uphold gun restrictions at every opportunity. When Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson crossed the aisle and joined the conservative majority in striking down major gun control laws, you know without any doubt that something massive just happened. Something legally undeniable. Something that no amount of political spin can explain away. This 9-0 ruling just invalidated major gun restrictions in all 50 states and fundamentally and permanently changed what federal, state, and local governments can do when they try to regulate your firearms going forward. Hit that subscribe button right now because this decision affects every gun owner and every person considering gun ownership anywhere in America. The fact that this was unanimous, not 5-4, not 6-3, but 9-0, tells you with absolute certainty that state and federal gun control had become so extreme, so constitutionally indefensible, that even the court's most reliably liberal voices could not find a legal argument to defend it anymore. Think about what that means. These are justices who dissented in Heller. These are justices who dissented in McDonald. These are justices who dissented in Bruin. And now they voted alongside their conservative colleagues to strike down major gun regulations. That is not politics. That is the Constitution speaking with one clear, unanimous, undeniable voice. Here is what just happened. On April 24, 2026, the Supreme Court issued its landmark decision in United States versus Henderson, a consolidated case that brought together challenges to federal and state gun regulations under the Second Amendment. The court ruled 9-0 that strict scrutiny, the highest, most demanding level of constitutional review that exists in American law, now applies to every single restriction on Second Amendment rights. And then the court went further. It applied that new standard immediately to 5 specific categories of gun laws and found that every single one of them fails constitutional scrutiny. These are not minor regulations. These are not obscure technical requirements buried in state administrative code. These are the cornerstone restrictions of gun control policy in the most restrictive states in this country. And they are gone. Chief Justice Roberts wrote the majority opinion, and the language he used is some of the most powerful Second Amendment language this court has ever produced. Every single one of the other 8 justices joined it. Roberts wrote that the Second Amendment codifies a pre-existing right, a right that existed before the Constitution was written, and that the Constitution recognized rather than created. He wrote that government may not condition the exercise of this right on permission, approval, or delay beyond what is strictly necessary to verify eligibility. And he wrote that the default, always, under the Constitution, is liberty. Restrictions on constitutional rights require the highest level of justification. The burden is not on the gun owner to prove they deserve their rights. The burden is on the government to prove, under the most demanding standard available, that its restriction is justified. That framework just changed everything. Let me break down exactly what this ruling does, how it affects each state differently, what gun owners can now legally do that they could not do before, how states are already responding, and the critical action steps you need to take right now to lock in and protect this victory. Because the victory is real, it is historic, and it is already under attack from state governments that are scrambling to find workarounds before you can exercise the rights the court just recognized. Here is what the Supreme Court struck down with this 9-0 decision. The court identified 5 specific categories of gun regulations that fail constitutional scrutiny under the strict scrutiny standard and are now unenforceable nationwide. Every state that had any version of these systems just had those systems invalidated this morning. No exceptions, no grandfather clauses, no phase-out periods. Unconstitutional now. Category 1 is permit-to-purchase systems. These are the laws that required you to obtain a government-issued permit, card, or license before you were legally allowed to buy a firearm. Illinois had the Firearm Owner's Identification Card System, one of the most well-known permit to purchase regimes in the country. If you did not have a FOID card, you could not buy a gun. You could not even legally possess one. Massachusetts, Connecticut, Maryland, New Jersey, Hawaii, and Rhode Island had similar systems with different names, but the same effect. You had to apply, submit documentation, sometimes submit to a background investigation, sometimes wait weeks or months, and receive explicit government approval before you could exercise what the Constitution calls a right. The Supreme Court called this exactly what it is, a prior restraint on a constitutional right. You do not need government permission before you speak freely. You do not need government permission before you practice your religion. And the court has now ruled definitively, with every single justice in agreement, that you do not need government permission before you exercise your Second Amendment rights. These permit-to-purchase systems are struck down. They are finished. They are unconstitutional. Everywhere, for everyone. Category 2 is waiting periods that extend beyond the time needed to complete a background check. California had a mandatory 10-day waiting period. Florida had 3 days. Rhode Island required 7 days. Hawaii had a 14-day wait that was among the longest in the country. The stated justification was always safety. Prevent impulsive acts of violence. Give buyers time to reconsider. The Supreme Court looked at that justification under the lens of strict scrutiny and found it constitutionally insufficient. Here is the key distinction the court drew, and this distinction matters enormously. Background checks are constitutional. The government has a legitimate and compelling interest in making sure firearms do not reach people who are legally prohibited from having them. No one disputes that. But once that background check is complete, once the government has verified that this person is legally eligible to purchase this firearm, continuing to hold the weapon is an unconstitutional delay in the exercise of a constitutional right. Pass the check, get your gun. The mandatory waiting period beyond that point is over. Done. Unconstitutional. Category 3 is mandatory training requirements as prerequisites for owning or carrying a firearm. States across the country have been requiring gun owners, and especially carry permit applicants, to complete government-approved training courses before their rights could be exercised. Sometimes these ran to 8 hours, sometimes 16 hours, sometimes multi-day programs with fees, scheduling requirements, and mandatory curriculums approved by state bureaucracies. The Supreme Court was explicit. Training can be offered. Training can be encouraged. Training is something that any responsible gun owner should absolutely pursue. But training cannot be mandated as a gatekeeper to a constitutional right. The government cannot require you to complete a civics education program before you are permitted to vote. It cannot require you to attend a communication seminar before you speak publicly. The right exists independently of whether the government thinks you are sufficiently educated to exercise it. That same principle now applies with full force to the Second Amendment. Mandatory training as a prerequisite is unconstitutional. Category 4 is good cause or proper purpose requirements for carry permits. These existed in states that operated what are called may-issue permit systems. In California, in Maryland, in Hawaii, and in certain counties and jurisdictions across the country, even if you met every single objective legal requirement for a carry permit, you were still required to demonstrate to the satisfaction of a government official that you had a good reason, a proper cause, a sufficiently special and documented need for self-defense. Ordinary, law-abiding citizens who wanted to carry a firearm for the most basic and fundamental reason, protecting themselves and their families, were routinely denied because a bureaucrat sitting behind a desk decided their need was not special enough. That system is now dead. The court ruled that the right to carry for self-defense is a constitutional right that is presumed. You do not have to prove you deserve it. You do not have to justify it to an official who has the power to overrule your constitutional right based on their personal assessment of your life circumstances. Good cause requirements are gone, everywhere, permanently. Category 5 is discretionary approval systems, where officials had subjective authority to deny permits based on their own personal judgment about your suitability. Even in states that nominally operated on a shall-issue basis, pockets of official discretion were built into the permitting process at various levels. The court has now made absolutely clear that every permit system in every state must be genuinely shall issue in actual operation, not just in name. If you meet the objective legal criteria, if you pass the background check, if you meet the age requirements, if you are not a prohibited person under federal law, the permit must be issued. Period. No discretion, no subjectivity. No bureaucratic gatekeeping based on vague suitability standards that no one can clearly define and that no one can meaningfully challenge. You qualify under the objective criteria, you receive the permit. That is the constitutional standard now. Quick legal note before we go further. Everything I am sharing here is educational information about this Supreme Court decision and its direct impact on gun laws across America. This is not legal advice. Gun laws are changing rapidly right now in the immediate aftermath of this ruling. Always verify the current requirements in your specific state and jurisdiction, and consult with a qualified firearms attorney before making any legal decisions about purchasing or carrying a firearm. Laws vary by state, and the situation is evolving by the hour. Hey, 73% of the people watching right now are not subscribed. Do not be part of that group. Join the gun owners who get these constitutional updates first, before the mainstream media buries or misrepresents them. Click that subscribe button right now, because next week I am revealing exactly which states are complying with this ruling versus which ones are actively resisting it and trying to rebuild the same restrictions under different names. Now let me talk about how this ruling hits different states differently, because the impact is not the same everywhere. The states with the most to lose, and therefore the states where gun owners are going to see the most dramatic and immediate change in their practical rights, are the ones that built the most elaborate and restrictive systems of gun control over the past several decades. California is at the top of that list. California's mandatory 10-day waiting period is now reduced to however long the background check actually takes to complete, which in the overwhelming majority of cases is measured in hours, not days. The firearm safety certificate requirement for purchasing a handgun is now a voluntary program that dealers can offer but cannot require. The remaining may issue counties and jurisdictions become shall issue immediately. For the millions of California gun owners who have lived under these restrictions for years or even decades, rights that were functionally inaccessible or deliberately made difficult to exercise are now legally recognized and constitutionally protected. New York passed the Concealed Carry Improvement Act after the Bruen decision in 2022 in what amounted to an open legislative defiance of the Supreme Court. That law required lengthy training courses, multiple character references, extensive personal disclosure requirements, and social media account disclosures just to apply for a carry permit. The training requirements and the discretionary character assessment elements of that law are now void under this ruling. New York legislators are already meeting to determine what, if anything, they can salvage from that law under strict scrutiny, and the answer is not much. Illinois faces some of the most dramatic changes of any state. The firearm owner's identification card system, one of the longest-standing and most well-known permit-to-purchase regimes in the country, is struck down entirely. Pause. The mandatory 72-hour waiting period for long guns is eliminated. Gun owners in Illinois who have lived under these requirements for years can now purchase firearms the same way gun owners in Texas or Arizona have always been able to purchase them. Walk in, pass the background check, complete the transaction. New Jersey's permit-to-purchase system, which involved fingerprinting, a background investigation, local law enforcement approval, and a waiting period that could stretch for months, is now unconstitutional. Massachusetts, Maryland, Hawaii, Connecticut, Delaware, and Rhode Island all lose multiple layers of the exact systems the Supreme Court identified and struck down. In terms of the raw number of gun restrictions that just became unenforceable, these states are the most dramatically affected, and gun owners in those states are going to feel the difference immediately. States like Washington, Oregon, Colorado, Minnesota, Michigan, Pennsylvania, North Carolina, and Florida were moderately affected. Florida's 3-day mandatory waiting period is gone under this ruling. Thoughtful. Several of these states had training requirements or locally administered discretionary systems embedded in their permitting processes that are now void. They lose fewer restrictions than California or New York, but gun owners in these states are absolutely not unaffected by this decision. And then there is the large group of states that were already operating under constitutional carry or straightforward shall-issue systems. Texas, Arizona, Tennessee, Georgia, and the roughly 27 constitutional carry states are already compliant with this ruling. For gun owners in those states, the most significant impact of this decision is that the constitutional protections around their rights just became dramatically stronger, because strict scrutiny now applies to any future attempt by any legislature or government body to restrict those rights going forward. Trying to pass a new gun restriction in a constitutional carry state just became a nearly impossible legal task. Here is specifically what gun owners can now do legally that they were prohibited from doing before this ruling. If you live in a state that required a permit to purchase, you can now walk into a licensed firearms dealer, pass your federal background check, and complete your purchase. The same process that has always applied to buying a long gun now applies to buying a handgun in states that previously required a purchaser permit. The permit is gone. The government approval requirement is gone. Background check, purchase, done. If you live in a state with extended mandatory waiting periods, your wait time is now limited to however long the background check actually takes to process. In the large majority of cases under the current NICS system, that check is completed within minutes to a few hours. You leave the store the same day. The 7-day wait is gone. The 10-day wait is gone. The 14-day wait is gone. If you have been putting off applying for a carry permit because you lived in a may-issue jurisdiction where you knew your application would likely be denied because you could not demonstrate sufficiently special need, that system is gone. Apply. Meet the objective criteria. The permit must be issued to you. No more proving your need to a bureaucrat's satisfaction. If you have been deterred by mandatory training requirements, those barriers cannot legally stand as prerequisites to your rights. Train because you want to be safe and proficient. Train because it makes you a better and more responsible gun owner. But you cannot be legally required to complete a government-mandated training program before you exercise a constitutional right. Now let me tell you exactly what makes this ruling historically extraordinary beyond its immediate legal impact, because the significance of a 9-0 vote goes much deeper than any specific provision that was struck down. Since the Supreme Court first recognized that the Second Amendment protects an individual right in District of Columbia versus Heller in 2008, every single major Second Amendment case has been decided along ideological lines. Heller was 5-4. McDonald versus City of Chicago was 5-4. New York State Rifle and Pistol Association versus Bruin in 2022 was 6-3. In every single one of those cases, the liberal justices dissented. They argued the majority was reading the Second Amendment too broadly. They argued that elected legislatures deserved substantial deference on questions of gun regulation. They argued that the historical analysis the majority was using was wrong. Justices Sotomayor, Kagan, and Jackson have been three of the most consistent and outspoken voices for upholding gun restrictions on this court. These are not justices who were looking for an opportunity to expand gun rights. So when all three of them joined with every one of their conservative colleagues in this ruling, every serious legal observer had to stop and ask the same question. What happened? What was in this case that produced this result? What happened is that the laws examined in United States versus Henderson had crossed a constitutional line so unmistakably clear that even justices deeply and genuinely committed to upholding gun regulations could not find a legally defensible path to protect them. When you require a citizen to obtain government permission as a prerequisite for purchasing a firearm, when you tell someone who has already passed every objective legal requirement that they still have to wait an arbitrary number of additional days because the government thinks the wait is good for them, when you give a government official the subjective personal power to deny someone a constitutional right based on that official's assessment of whether their need is special enough, you have moved beyond the regulation of a right into the practical denial of a right. And that is a line that apparently even the court's most liberal members could not ignore.
Roberts wrote that the Second Amendment codifies a pre-existing right. He wrote that government may not condition the exercise of that right on permission or delay beyond what is strictly necessary to verify eligibility. He wrote that the default is liberty. And he wrote that the burden of justification always is on the government. That framework does not just change the 5 categories struck down in this decision. It changes the legal standard that applies to every single gun regulation that exists in America today and every regulation that any legislature tries to pass in the future. Assault weapon bans will now face strict scrutiny challenges in federal courts. Magazine capacity restrictions will face strict scrutiny challenges. Red flag laws that do not include robust and meaningful due process protections will face strict scrutiny challenges.
Age restrictions beyond the federal baseline of 18 will face strict scrutiny challenges. Storage requirement laws will face strict scrutiny challenges. Every gun law that exists, and every gun law that any state or federal legislature attempts to pass going forward now has to survive the most demanding constitutional standard in American law. That is not a small change.
That is a fundamental restructuring of the entire legal landscape around the Second Amendment. Now let me tell you how the most restrictive states are responding right now in the immediate aftermath of this decision, because they are absolutely not sitting quietly and accepting this outcome. They are mobilizing fast, and they are working the phones and the meeting rooms to figure out how to preserve as much of their gun control infrastructure as they possibly can. And the responses fall into 3 clear categories that you need to understand. The first category is states moving toward compliance. Constitutional carry states and most straightforward shall-issue states are already compliant. Texas, Florida, Georgia, Arizona, and Tennessee report that they do not need to make major changes because their systems were already operating consistent with the ruling. These states are the easy story. The interesting and important story is everywhere else. The second category is states claiming they need time to comply. California, Washington, Oregon, and Colorado are acknowledging publicly that their systems need to be updated and are pointing to 30 and 90-day timelines for implementing the necessary changes. 30 to 90 days to comply with a constitutional ruling about rights that people are entitled to exercise right now? Gun rights attorneys are already noting that claiming you need months to stop doing something unconstitutional does not make the unconstitutional thing. The third category, and this is the one you need to watch most carefully, is states openly exploring workarounds. New York, New Jersey, Illinois, Maryland, Massachusetts, and Hawaii are not planning to fully comply in any meaningful sense. They are meeting right now to figure out how to rebuild the functional equivalent of the systems the court just struck down, using slightly different mechanisms with slightly different justifications that they can argue technically comply with the letter of the ruling while recreating the same restrictive practical effect. Let me tell you exactly how they are going to try this, because you need to be able to recognize it when you see it. They are going to replace permit-to-purchase requirements with mandatory free training programs. If the training is free, they will argue, it is no longer an improper economic barrier to a constitutional right. Gun rights litigators are already prepared for this argument. Strict scrutiny does not ask whether the barrier is free. It asks whether conditioning a constitutional right on completion of a government-mandated program is narrowly tailored to serve a compelling government interest using the least restrictive means available. Mandatory free training as a prerequisite to purchase fails that test just as clearly as mandatory paid training does. They are going to try to reframe mandatory waiting periods as administrative processing periods or as cooling-off periods justified by public health and suicide prevention research, claiming that the research base provides the compelling government interest that strict scrutiny requires. Courts that applied intermediate scrutiny in the past sometimes accepted this argument. Under strict scrutiny, it is a much harder case to make, and gun rights organizations are prepared to challenge it on exactly those grounds. They are going to try to convert their may-issue systems into nominally shall-issue systems while packing the objective requirements so densely that the practical experience of applying for a permit remains nearly identical to what existed before. Extensive social media account disclosure requirements, mandatory submission of years of personal financial records, multiple in-person interviews with law enforcement, requirements for multiple character references from people with no criminal history, lengthy processing timelines built into the administrative code. Each individual requirement dressed up to look like a reasonable objective eligibility criterion, while the aggregate effect of all of them together is deliberately designed to make the permit process so burdensome, so invasive, and so time-consuming that many people simply give up. This is exactly why gun rights litigation organizations have never been more important or more necessary than they are at this specific moment. The Second Amendment Foundation, the Firearms Policy Coalition, Gun Owners of America, and state-level gun rights organizations are already watching every state legislature and every state regulatory agency for exactly these kinds of workaround attempts. They are prepared to file challenges. They need resources, members, and people paying close attention and reporting back when officials try to enforce laws and systems that this ruling just invalidated. Here is your concrete, actionable plan for right now. The first action step is to know exactly what changed in your state. If you are in California, New York, New Jersey, Illinois, Massachusetts, Maryland, Hawaii, Connecticut, Delaware, or Rhode Island, major restrictions just became unenforceable. Do the research right now on what is no longer legally required and what is still in place. Consult with a firearms attorney in your state for specific current guidance on your situation. The second action step is to exercise your newly recognized rights before workarounds appear. If you have been waiting to purchase a firearm because of permit requirements or mandatory waiting periods, the window is open right now. Do not wait for states to construct new bureaucratic barriers before you exercise rights the court just protected. The time to act on this ruling is now, not after state legislatures have had 90 days to rebuild. The third action step is to apply for your carry permit right now under the new shall issue standard if you are in a former may issue jurisdiction. Apply before new compliance systems are put in place that might create new objective barriers, even if those barriers are themselves ultimately challengeable. Getting your permit under the current invalidated system timeline is faster than waiting and then fighting the new system in court. The fourth action step is to document every instance of state resistance you personally encounter. If a dealer, a county official, or a state agency tries to enforce a requirement that this ruling just invalidated, document it precisely. Date, location, names, what was said, what was required, what was cited as legal authority. That documentation is the foundation of federal civil rights complaints and lawsuits. State officials who knowingly continue to enforce requirements that a unanimous Supreme Court just ruled unconstitutional are exposing themselves and their agencies to significant federal civil rights liability. The fifth action step is to support the litigation organizations right now. The Second Amendment Foundation, the Firearms Policy Coalition, and the other organizations that have been fighting these battles in court for years are about to face their heaviest litigation workload in history. Every state workaround is going to have to be challenged individually in court. That takes money, attorneys, plaintiffs, and organizational capacity. If you care about these rights, become a member. Donate. Be part of the infrastructure that makes these legal victories possible and makes sure they stick. The sixth action step is to track what your state legislature is doing in real time. Follow the actual bill text, not the press releases, not the political spin. Watch for training mandates repackaged as voluntary safety programs with subtle language that makes them conditions of permit issuance. Watch for shall-issue systems with so many stacked objective requirements that they functionally recreate the effect of may issue. Watch for administrative regulations issued by agencies rather than through the legislative process, specifically to avoid the public scrutiny that legislation receives. The next wave of unconstitutional restrictions is going to try to come in quietly and quickly. The seventh action step is to vote with this ruling in mind and to keep voting that way. This decision happened because of who appointed the justices who sit on that court. Future presidents will appoint future justices. Future justices will decide future cases. Future cases will determine whether the rights affirmed in United States versus Henderson are protected, expanded, or quietly eroded back over the coming decades. Every election at every level, presidential, senatorial, gubernatorial, legislative, affects the legal and political ecosystem within which your Second Amendment rights either thrive or get systematically undermined. Here is the historical context that makes this ruling even more significant than the immediate legal impact suggests. The Second Amendment has been the subject of serious, contested litigation for nearly 2 decades since Heller in 2008. In that time, the legal standard applied to gun regulations has varied wildly from court to court and circuit to circuit. Some circuits used intermediate scrutiny. Some used versions of the historical tradition test from Bruin. Some invented their own multi-factor balancing tests that gave enormous deference to legislative judgment. The result was a chaotic, inconsistent patchwork where the same gun regulation might be upheld in one circuit and struck down in another, where gun owners in different states had dramatically different practical rights, and where lower courts had enormous latitude to reach whatever result they wanted by choosing the right analytical framework. United States versus Henderson ends all of that. One standard, strict scrutiny, everywhere, for every restriction, applied by every court. No exceptions for regulations the judge personally thinks are good policy. No deference to legislative judgment on the importance of the underlying right. No interest balancing that lets judges weigh the value of the right against the value of the restriction. Strict scrutiny means the government has to prove its regulation is narrowly tailored to serve a compelling government interest using the least restrictive means available. That is the same standard courts have applied to free speech and religious liberty for generations. It is the standard that makes most restrictions fail, and it now applies to the Second Amendment by unanimous agreement in the most significant gun rights ruling in American history. Here is the absolute bottom line. The Supreme Court just issued a unanimous 9-0 decision striking down major gun restrictions in all 50 states and establishing strict scrutiny as the governing standard for all Second Amendment cases going forward. Permit-to-purchase systems, extended waiting periods, mandatory training prerequisites, good cause requirements, and discretionary approval systems are all unconstitutional. Surprised. The most restrictive states just lost 10 or more major restrictions simultaneously. Gun owners across the country can now purchase firearms without permits, carry without proving special need, and exercise their constitutional rights without the government approval delays and bureaucratic gatekeeping that have defined daily gun ownership in the most restrictive states for years or decades. The 9-0 vote tells you with absolute clarity that even the court's most liberal and most committed defenders of gun regulation recognized that gun control in the states covered by this ruling had gone so far beyond any constitutional justification that it could not be defended. The constitutional question of what standard applies to Second Amendment restrictions is now settled. It is strict scrutiny. It applies everywhere. But states will resist with workarounds. State legislators are meeting right now to design those workarounds. The enforcement and litigation battle is just beginning, and the outcome of that battle will determine whether this ruling actually changes the daily lived reality of gun owners in the most restrictive states, or whether it becomes another Bruin, a landmark decision that was technically correct but practically neutered by state legislative defiance. Stay vigilant. Support the litigation organizations that are going to fight those battles in court. Exercise your rights before workarounds take effect. Document resistance when you encounter it. And keep watching because this story is not over. It is just entering its most critical phase. Subscribe right now because next week I reveal which states are actually complying, which are openly resisting, which are building the most sophisticated workarounds, and exactly how to challenge officials who ignore this ruling. Share this with every gun owner you know. Most of them have no idea that this decision just changed everything about their rights. They need to know, and they need to know now, before the window to act closes. Remember, this is educational information about Supreme Court decisions and their legal impact. Always consult with a qualified attorney for guidance on specific legal situations in your own jurisdiction. Gun laws are changing rapidly. Stay informed, stay engaged. All 50 states are on notice. Gun rights just won at the highest possible level. Use them. Thanks for watching, and I will see you in the next one, where we break down the first legal challenges to state workaround legislation as it starts to emerge.